Imagine this. Your neighbor plays loud music every night from his house. As a result, you can't sleep at night in your own house. What can you do? Do you have a legal remedy? Hello and welcome back to the channel. In this channel, we like to break down laws and legal principles that you might encounter in your day-to-day lives. Today, we're diving into the fascinating area of tort law, focusing on the law of private nuisance. This principle governs conflicts between neighbors on how to use their property. So what is a private nuisance? And when will the law decide that something legally constitutes a nuisance? Let's discuss. Private nuisance occurs when someone's actions interferes with another person's enjoyment of their property. It's a civil wrong or tort that primarily deals with property rights. A successful claim usually requires proving that the interference is substantial and unreasonable. What this means is that everybody has the right to enjoy their property as they wish, without interference by other people. Going back to our example, imagine you're trying to sleep in your house, but your neighbor is constantly playing loud music late into the night, making it impossible for you to sleep. The ability to sleep in your house without disturbance is part of your right to enjoy your property, but at the same time, it is your neighbor's right to enjoy music in his property. That's his right to enjoy his property. But if your neighbor is using his land in a way which is unreasonable, then the courts might decide that he is causing a private nuisance. The courts will have to balance your rights against your neighbor's rights. There is, of course, a threshold that will have to be met for something to amount to a private nuisance. There are several elements that must be proven to establish a private nuisance. Number 1, substantial interference. This means the interference must be significant. Trivial annoyances like a few hours of loud music during a birthday celebration won't likely qualify. The courts will assess this on a case-by-case basis. In the landmark judgment of Hunter vs. Canary Wharf, the courts held that the interference must affect the ordinary use and enjoyment of the land. Number 2, unreasonableness. The interference must also be unreasonable. Courts often consider factors like the nature of the area, the duration of the nuisance, abnormal sensitivities of the parties, and whether the defendant's actions were intentional or malicious in considering whether something constitutes a nuisance or not. A classic example of this was the case of Sturgis vs. Bridgman. In this case, a doctor sued a confectioner for noisy machinery disrupting his practice. The courts held in favor of the doctor because the nuisance was unreasonable in a residential area. In this case, the courts made a distinction between residential areas and industrial areas. Basically, a factory making loud noise would not be a nuisance in an industrial district, but if the same factory was making noise in a residential district, it would be a nuisance. Number 3, damage or harm. Finally, the claimant must prove that they actually suffered harm. This could include physical damage to property like a broken window in your house, or interference with your enjoyment of the property like not being able to fall asleep in your own home. Now, not every claim of nuisance will succeed. Defendants have several defenses that they can plead which can absolve them of their liability. These include statutory authority. If the nuisance causing activity is authorized by legislation, the defendant might avoid liability. For example, a factory operating within legal environmental guidelines. Consent. If the claimant has given explicit or implied consent to the activity causing the nuisance. Prescriptive right. If the nuisance has been occurring for over 20 years without objection, the defendant may argue that they have a legal right to continue. If a claim for private nuisance succeeds, what are the remedies available to the claimant? There are typically 3 types of remedies that the courts might grant. Number 1, injunctions. To stop the nuisance, for example, requiring your neighbor to cease certain activities at night. Number 2, damages. Compensation for harm caused, such as repairs or inconvenience. Number 3, abatement, which allows the neighbor to take reasonable steps to stop the nuisance themselves, like trimming overhanging branches from your neighbor's tree. So in conclusion, the law of private nuisance is essential in safeguarding your rights with regard to your own property to ensure that you are able to enjoy your property in any way you like, while at the same time protecting your neighbor and his rights to enjoy his property. If you found this video useful, please do consider liking the video and subscribing to the channel. I'll see you in another episode. Take care. Bye.